Hi, we're here today in Washington, D.C. at the headquarters of the Equal Employment Opportunity Commission. My name's Josh Ulman, and I'm with CUPA-HR's Government Relations team. We're here to interview Jim Paretti, who's Special Assistant and Counsel to Commissioner Victoria Lipnic. We're going to head into the office now. We're here today with Jim Paretti. Jim, why don't you tell us a little bit about the EEOC and its mission?
Sure, my pleasure, Josh. Well, basically, we are a bipartisan, 5-member commission, and it's our role under the Civil Rights Act and other anti-discrimination laws. We enforce Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, and a number of other laws, all relating to employment discrimination in the workplace. What that means is, on a practical basis, is in the private sector, someone believes that they've been discriminated against, they want to bring a charge. They generally have to come to us first or to one of our state agencies. We sort of process that charge. So we will do an investigation where appropriate. In some instances, we will actually bring litigation on behalf of an individual or a class of individuals if it's a case of sort of national significance or importance. So we investigate, we litigate. Where there have been alleged violations of the law, we work to mediate and conciliate them. And frankly, our goal in the first instance is to eliminate discrimination in the workplace. So plainly, anything that will get us to there, we try to do. And finally, what they sort of do as a policy matter is the Commission issues regulations and sub-regulatory guidance on various interpretations of the law, how we will enforce certain provisions of the law, what we think a provision of Title VII means or doesn't mean, things of that sort. And that's intended to both guide and inform stakeholders, both employers and employees. So I would say that's probably the last, or if not least, component of our mission is outreach and education, informing employees and applicants of their rights under the laws, as well as employers of their obligations, what we expect of them and what's expected of them under the law.
Thanks, Jim. Can you tell us a little bit about some of the initiatives that the agency is working on right now?
Sure. Well, broadly speaking, we've been developing a strategic plan which will include a national enforcement plan to guide the agency over the next 5 years. But more specifically, and probably of more direct interest to your members, it's been a priority of the chair and the focus of the commission over the last year or so to focus on areas relating to sort of barriers to entry in the workplace. Thinking in particular things like background checks, the use of credit information in making employment decisions, the use of criminal records, conviction and arrest records in making employment decisions. And on that, in fact, I guess it was last month, we issued updated guidance that sort of consolidates and updates the guidance we've had on the books for 20 years relating to criminal record history.
Can you tell me why the EEOC has jurisdiction over criminal background checks? Explain a little bit for our audience.
Sure. It is not, if you were to look at the civil rights law, it is not, for example, that criminal record is criminal history is a protected class under the law. It's not that. What it is under Title VII, the Civil Rights Act, it informs the use of criminal record information in making employment decisions in potentially one of two ways. The first, which we would call disparate treatment theory, which is fairly common sense, is the hypothetical employer who says, for white applicants, they're not required to undergo a background check, but for black or Hispanic applicants, I'm going to run a criminal records check and then make decisions based on that. That's pretty common sense. You're treating two groups of employees differently based on their race or their national origin. So that right there would be plainly a potential violation of Title VII under what we call disparate treatment. What I think has gathered more attention lately and is of greater interest is what we call the disparate impact model. And what disparate impact says is where you have a policy that on its face may be neutral, it's applied the same across the board to all applicants or all employees, but the results of the test or the results of the screen end up having a disparate impact on a protected class. And to put that in plain English, I'm an employer and I run a criminal background check on all of my applicants, and I don't hire folks who have felony convictions. Well, that's a neutral policy. I'm applying it the same to everybody, to all comers, without respect to sex or gender or religion or race. But when I use that, at the end of the day, it turns out I'm screening out a disproportionate number of, say, African Americans as opposed to the number of whites in the hiring pool, where a neutral practice has a disproportionate impact on a protected class. That's disparate impact liability, and that's something that we have jurisdiction over to investigate and potentially litigate under Title VII, which broadly prohibits employment discrimination.
If a practice causes a disparate impact, is it automatically unlawful?
No, not at all. In fact, the law recognizes that there may be neutral practices that have an adverse impact but are, in fact, justified. And the legal standard under Title VII is what the test is called job-related and consistent with business necessity. Again, in plain English, what that suggests is a nexus between the test that you're using and the job at hand. By way of example, I run a drugstore, and in hiring my pharmacists, I go and check to make sure that they don't have any drug possession or intent to sell convictions in the last 10 years. Why am I doing that? Well, it's fairly obvious. You would not want someone with access to narcotics and controlled substances who has a record of being a drug dealer. So that's the sort of thing you look at to determine, in that instance, even if the test did turn out to say, well, running this background check results in an adverse impact on certain groups, an employer could well argue that, well, that's job-related and consistent with business necessity, and thus justified under Title VII.
So why did the agency issue new guidance on this subject?
Sure, good question. Well, actually, I think I would characterize it as we've updated our existing guidance and sort of consolidated what was out there, because going back to as far as 1987, we've had policy statements up concerning the use of arrest records, conviction records, statistics relating to arrests and convictions. So this is really not a new area for us, but over the years we've had a number of different documents scattered in different places. What the intent was here was to consolidate that, sort of update it, bring it up into the 21st century. And I think there's a number of reasons for that. Two that immediately come to mind. One is, with the advent of internet technology, and there's so much more information out there and readily available to employers, it's our sense that our guidance wasn't sort of keeping up with that and reflecting that fact that these may be used a lot more frequently than they had in the past. And second, while we've had this existing policy stuff out there, back in 2007, in a case called L versus SEPTA, the Third Circuit, was a case regarding criminal conviction records. The Third Circuit examined our guidance, and while they didn't criticize the substance of it, they did sort of come to the conclusion that it was not especially well-reasoned, and they didn't afford it a whole lot of deference because it wasn't particularly long on legal analysis or the case law and underlying why we take some of the positions that we do. So I think in deciding to revisit this topic and issue updated guidance, it was the hope that we'd be able to put something out there that's a little more detailed and thoughtful, and courts will give it the deference which it is due.
So how does this updated guidance differ from the former guidance?
Sure, good question. Broadly speaking, I would say it's not significantly different. What we've tried to do in this updated guidance is to sort of, as I mentioned, collect various policy positions and statements that were out there and to put them under one umbrella. We've tried to modernize and sort of bring things up to date with 21st century fact patterns and provide more illustrative examples, flesh out the legal analysis a little bit more to capture some of the cases, the number of cases that have come down in the intervening 20-some years that have addressed this issue. But broadly speaking, I don't think you'd find in this updated guidance any real sea change or significant new policy direction that the agency is going to be taking. The converse of that, I would say, as an employer, I think you would not find a whole lot of reason to dramatically change the practices that are in existence today because of this guidance that we issued last month.
We've received some questions about something referenced in the guidance called individual assessment. Could you explain that concept a little more?
Sure. And
what it means in the guidance?
Right. Well, as a best practice, and I want to stress at the beginning, we've made this explicit. Title VII does not require this, but as a best practice in appropriate circumstances, an employer may want to consider providing for what we've called, or some have called, an individualized assessment. What does that mean? That means, in general, I'm an employer and I conduct a background check. And my general rule is if you're convicted of X, Y, or Z, I'm going to screen you out, put you on the no pile. What we've recommended in this guidance as a best practice is, where appropriate, you may want to add to your policy a provision that provides for taking a second look, seeing if there are extenuating circumstances, offering an applicant the opportunity to explain a conviction. In many instances, or at least in certain instances, it may be as simple as mistaken identity. You've got the wrong John Smith, and I can show you why. In other cases, and I would say here we're sort of subject to a rule of reason. If I am running a pharmacy and I screen for drug possession and intent to sell narcotics crimes. I'm not sure that as an employer I need to give a whole lot of time to say, well, explain to me what this conviction is. Again, as we talked about earlier, there's a fairly tight nexus between what we're screening for and the job at hand. In contrast, I am a large retailer, and I'm taking applications for clerks or stockroom folks, and I say, well, I notice here there's a 15-year-old disorderly conduct conviction on somebody's record. You give someone the chance to explain it. It turns out that, well, they were the unlucky drunk in college who, when they mooned somebody off the balcony, they happened to be doing it to the police chief's daughter, and bang zoom. I would submit, does something like that, put in context, have as much, if any, bearing on the ability to do, a teller's job, a clerk's job, 15 or 20 years later, with no further brushes with the criminal justice system. So that's what, as a best practice, we've talked about in terms of an individualized assessment. It is, where appropriate, providing folks the opportunity to either explain, offer up additional information as to why someone who might otherwise be screened out under the policy shouldn't in this particular instance. And again, I would subject that to largely the rule of reason. I don't think any employer would need to spend a whole lot of time asking, I'm running a daycare center, and I'm going to screen out folks based on convictions of violence against children. I really don't see any employer needing to spend much time offering up the ability to explain that kind of conviction. So, again, it's a concept that we've fleshed out more, but I think it's important to note it's not a requirement so much as a recommendation or something for employers to consider in appropriate circumstances.
What if an employer is required by state or federal law to do a background check? How does this guidance interact with that other legal requirement?
Great question. Well, there's two answers to that. I think it's important to break them out. There's sort of two different questions there. With respect to federal law, and our guidance is very clear on this point, if an employer is conducting a background check or screening out applicants pursuant to the requirements of federal law, so long as it's doing so in a non-discriminatory manner, treating all applicants the same, that is a defense under Title VII, and an employer will not be found liable. By way of example, and I stress this is hypothetical because my knowledge of the banking laws are not tremendously deep, but if, for example, some of the financial laws require that a bank not hire folks who have convictions of larceny or theft within the last 10 years, that's a federal law requirement. An employer who is screening applicants out based on that federal law requirement does not face liability under Title VII. Title VII doesn't preempt that existing federal law. With respect to state law, it's a slightly more nuanced question, insofar as Title VII does and has, since it was enacted in 1964, contain a preemption clause, which means that in general, obeying a state law will not lead to liability under Title VII unless the state law is compelling you to do something that violates Title VII. That's a little bit circular, but again, by way of example, if an employer is conducting background checks pursuant to state law and screening out applicants, if that state law potentially violates Title VII, there could potentially be liability. That has been the case since 1964. That's not something new or not something that the agency is taking a new focus on. In fact, my boss, Commissioner Lipnic, was very clear at our meeting that pursuing or investigating charges of employers who are screening folks out pursuant to state law is really not where an agency, a strapped agency, should be investing its resources. Again, I guess by way of examples, the clearest way to illustrate, if you have an employer who, pursuant to state law, is screening out candidates for security guards based on weapons convictions, I think we'd all agree there's a pretty close relationship to job-related consistent with business necessity, and it's hard to imagine that law doesn't pass muster under Title VII. Sitting here at this moment, I'm not sure I could think of one, but if the hypothetical state enacted a law that said no one who's ever been convicted of so much as a parking ticket or speeding ticket can ever work in the state again, that's fairly broad. I think it would be hard to argue that that is going to be, in all instances, job-related and consistent with business necessity. So there you might have a potential Title VII violation. But again, I stress, it's not our intent to sort of be playing gotcha or trying to second-guess state legislatures with respect to these laws, but it is important that employers know that at least it's out there. Compliance with the state law is not an automatic shield as a legal matter. As a practical matter, I think in most instances, employers who are complying with state laws shouldn't be terribly worried about changing their practice.